Good afternoon. Thank you. Thank you for the introduction, Kelly. I'm Geo Brackbill with the Pennsylvania Utility Law Project. I am the Utility Justice Project Manager, and my co-presenter today is Pereira, Supervising Attorney. We're going to discuss the end of the winter moratorium for utility terminations, as well as the end of LIHEAP season, and a little bit more about the latest changes in utility assistance and advocacy today. If you have any questions, please feel free to put them right in the Zoom chat box, and we'll try to monitor them and take them as they go. So just a little bit more about us. Who are we as PULP? If you're not familiar, we're the folks who specialize in residential utility and energy matters, and we provide info, assistance, and advice to low-income consumers. We're based out of Harrisburg, and we serve individual clients through direct services and group clients statewide. So our mission is to advance just and equitable access to safe and affordable utility services for Pennsylvanians experiencing poverty. And we value the right of people to have a healthy home and a thriving community. Next slide, please. So PULP services, like I said before, we have this direct representation component where individuals can call into our hotline and we'll open a case to and reach out on their behalf to utilities or other third parties, whoever they need connected with, and make the referrals that they need to local legal aid offices or other legal aid or other social service organizations in the community. So the ultimate goal through our direct services is to keep people connected to service. And then we also represent organizations and other group clients involving utility access and affordability at the PUC level when we intervene in those cases. So our other work and service that I want to mention is, like I said, through rate cases, universal service plans, and other PUC proceedings, we advocate for improvements to the assistance programs for low-income consumers that the utilities run. And so when we're talking about utilities, we're talking about energy, gas, electric, water, and then also broadband telecommunications, and we would do policy work on those areas. And also, not to be left out, is our education and technical assistance services. So if you are having you come across a complicated utility matter and you need case consultation, you can reach out to us. And then we also do trainings if your staff is interested in one. So next slide. Today's webinar, we'll talk about LIHEAP to kick us off, and then go into some of the other temporary relief programs that were available during the COVID era, and some are still available, and then universal service programs. Then we'll give you some tools for your toolkit on how to prevent terminations and how to restore service if your client's already shut off, and then some special protections for certain groups of utility customers, and last but not least, disputes and complaints. Next slide. So happy spring to everyone, but with that happy spring, if you're in the utility space, you know that comes with the end of the winter moratorium. So we made this webinar timely because tomorrow, March 31st, is the last day that low-income households are protected from termination in the winter, and that's defined as those at 250% of the federal poverty income guidelines or below. And this applies to heat-related service, so gas, electric, and it can be water as well, that's regulated by the PUC. If they were already turned off prior to December 1st, the winter moratorium didn't guarantee that they would have their service restored if it was already off. But if they were on, they would have been prevented from getting shut off, and their bills would continue to accrue. I do want to mention that this winter moratorium that I'm talking about doesn't apply to municipal water and wastewater or electric co-ops that we see in some parts of the state, or deliverable fuels. So if they we're out of oil or propane and more wood at the beginning of the winter moratorium, that obviously it doesn't keep them from running out. But so we're going to talk more about things that you can do to help your clients that might be facing shut off as soon as Monday morning. So with that, I just want to give you one more slide before I pass it off to Ria about why we're talking about this. And I'm sure most of you already know about the lasting harm that utility insecurity can cause, but I want to touch on the whole list here of negative health outcomes that can occur as a result, because utility debt eventually can result in involuntary termination, and then involuntary termination turns into things like exposure to unsafe temperatures, preventing from families from being able to properly sanitize, cook, clean in their homes, and then it can also interrupt family unity. So one of the consequences is that Children and Youth Services may remove a child from the home if water or energy heat is turned off. So we just want to really drive home the importance of this work. With that, I will pass it off to Ria to talk about LIHEAP.
Thanks, Gio. So as was mentioned, we'll be moving into the low-income home energy assistance program portion of this presentation, otherwise known as LIHEAP. So LIHEAP is still open for this program year. It will be open until April 28th of this year. And those dates change by program year a little bit. So keep track depending on which program year you're working in. But for this year, at least, we're going through April 28th. We're going to be going through each of these components in a little more detail in the next few slides, but we wanted to give you some wayfinding on this first LIHEAP slide. So LIHEAP, the three components are cash grants, crisis grants, and then crisis interface. For this program year, the minimum cash grant amount for LIHEAP is set at $300 and the maximum is set at $1,000. Now, in addition to that, we wanted to mention that there is a $150 supplemental grant that is or has gone out for all cash grant recipients due to extra or available emergency federal funds. Now, for those of you who don't know, LIHEAP is a federally funded program. It is administered through DHS. So with those additional federal funds, we have seen that additional $150 supplement. For crisis grants, again, we'll talk about this in the next few slides with a little bit more specificity, but the minimum this year is set at $25. The maximum was set earlier in this year at $1,000, but it's actually increased subsequently to $2,000. So if you're working with someone who went in earlier for a crisis grant, they actually can go in and reapply and see if they meet the crisis grant qualifications, which we'll talk about again in a minute, and they might get up to that new maximum, which is $2,000 for crisis. We'll talk about this again in a few minutes, but in order to qualify for a crisis grant, the crisis must be resolved. Now, this can be done with crisis funds standing alone or in combination with other sources of funding. And we'll talk about this in a little more detail in a few minutes as well. Crisis interface is really geared towards repair and replacement of broken heating systems. So those furnace repairs and replacements. And really, these can be coupled with the other components of LIHEAP, and we'll give you some more information about crisis interface in a few minutes as well. So when you're applying for LIHEAP, when a client you're working with is applying for LIHEAP, we recommend looking first to see if the person can apply through the Compass portal. The reason being is if the person applies to the Compass portal, they should receive a preliminary eligibility determination at the end of their Compass application if applying online. However, you can also apply in person at local county assistance offices. So as promised, some more specificity about the individual components of LIHEAP. So let's first talk about some of the eligibility requirements for LIHEAP cash grants. So eligibility for LIHEAP cash grants is set at income that's at or below 150% FPL. Now, there's a little bit of an advocacy tip here because income can be measured in two ways. It can be measured as either the month previous to the application or 12 months before the application, whichever benefits the applicant. Now, this is particularly important if you're dealing with people who've had recent job losses, job changes, if they're seasonal workers. This calculation kind of tip or trick can help to potentially get them under that 150% line. Second requirement we're going to spotlight here is there has to be a home heating responsibility. Well, first of all, what does that mean? Home heating responsibility means that they are responsible for paying the main source of heat. Now, this can be shown in a number of ways. Often utility companies have direct communication with county assistance offices to verify home heating responsibility, but sometimes it can get a little more tricky, especially if you're dealing or working with a tenant. So a tenant can show home heating responsibility. That's the first kind of golden rule. Sometimes it requires things like landlord verification, or if the person pays for heat through rent, for example, it might require, for example, a lease that shows that they are responsible for that main source of heat through rent. Keep in mind that if you are working with a tenant, the rules get a little bit sticky about if they're having heat included in their rent. They still can be LIHEAP eligible, which is very important, but they may only be eligible for 50% of the cash grant in those circumstances. And then the last eligibility criteria we're going to spotlight here is PA residency. And if you're working with someone who might have a seasonal residency, please let us know. There's some additional tips, tricks, and rules related to that as well. So next, let's talk about some eligibility criteria for crisis grants. The first three should look very familiar because we just talked about them. So crisis grants also require a showing of the household income that's at or below 150% FPL, a home heating responsibility, as well as residency. In addition, crisis grants require a crisis. So what is a crisis? How is it defined for LIHEAP purposes? An actual or imminent home heating emergency. So how is this shown? What's in practicality going to be shown by this? It's shown in a number of ways. The most likely ones you're going to see is that there is a termination notice, or if you're working with deliverable fuel customers, 15 days or less of deliverable fuel. One rule change we wanted to spotlight here, excuse me, is that crisis grants may be issued even if there is a temporary emergency or medical hold on the account. This is a rule change from previous years. Apologies. So if anyone runs into a situation where for some reason crisis is not available to them, in these situations, please let us know. It's something we are keeping an eye on. And then, as I mentioned on the introduction slide to this section, the crisis grant has to resolve the crisis. Now, this can be taken standing alone, so if the crisis funds are enough to resolve the crisis, or this can be taken in combination with other funding. So if the person has certain available funds, if there are hardship funds available, and Gio will be talking in a few slides about what hardship funds are. They're available through utilities. This can be coupled with other sources of funding. The other important tip or trick to keep in mind here is that utilities sometimes can and will agree to accept less than that total amount due to resolve the crisis, especially if the person is LIHEAP eligible. So sometimes it requires some advocacy through the utility, and there might be some resolution in that avenue as well. So I have one question here before we move on from Seamus, who's asked, when should crisis maxes have been changed? Seamus, I'm trying to kind of spotlight the issue in your question, but I think what you're asking is when the crisis maximum grant amounts have changed. Now, they do change first from year to year, so keeping track of what they are in the individual LIHEAP state plans is very important. They recently did increase within this program year from $1,000 to $2,000. So that's an additional increase of $1,000, where if someone previously got crisis grants, they can, in theory, come back if they meet the eligibility requirements and reapply for that as well. And please let me know if that did not answer your question, Seamus. All right, some other uses, essentially do's and don'ts for crisis grants. So what can they be used for? What can they not be used for? So crisis grants can be used for paying late fees, reconnection fees, as well as reasonable delivery fees for fuel. That's all okay in terms of crisis grants and in terms of the LIHEAP rules. Crisis grants may not be used for paying security deposits. However, in Pennsylvania, there is a restriction for regulated utilities. So there's larger utilities in Pennsylvania for charging security deposits for what we call CAP eligible households. And we'll talk more about CAP in a few minutes here, but it's essentially those households that have household income that are at or below 150% FPL. So that might be kind of a way of mitigating the cost of security deposits if you're working with low-income households. I think I'm going to just go through this really quickly before turning it back to Gio to give you a little more information about the crisis interface program. So as we talked about on the intro slide, the crisis interface program is really geared at those furnace repairs or replacements of those broken heating systems. Applicants can apply for a crisis interface on the same application if they indicate a furnace is broken or in need of repair. The county assistance offices will screen for eligibility, and then they'll often refer the case to local weatherization agencies to provide and perform essentially the crisis work. And then the applicants may also be screened for standard weatherization methods, including cooling equipment assistance or clean and tunes potentially through, again, those weatherization providers. So some available benefits under crisis interface include repair of heating systems, loan of auxiliary heaters, repair gas and other fuel lines, even replacement of unrepairable heating systems potentially can be included under this, repair of hot water heating systems, heating system pipe thawing services, even things like repair of broken windows, which kind of come part and parcel with the heating system in order to make it really operable, and then provision of blankets. And then I'm going to go ahead and turn it over to Gio.
Great. Thank you, Ria. And there's one more question in the chat. When within this season did the amount change? If a $1,000 grant was made in March, would the applicant be eligible to reapply? So the change went into effect on the end of February, so February 28th. And so if they only received $1,000, they can apply again and get the full crisis benefit up to $2,000 if they didn't receive $2,000 when they applied and they are in need. So either if they have a deliverable fuel, 15 days left of fuel or less, or if they have, they're at risk of termination for other heating types. So temporary COVID related relief and other federal programs. Next slide. I just want to touch on two different programs that you should be aware of if you aren't already. Now, different counties may or may not have the Emergency Rental Assistance Program funding left. So definitely check with your county ERAP administrators to see if this is an option for renters that are below 80% of the area median income. And some counties they changed their program or converted it into something else. Like for example, in Pittsburgh, they have Rent Help PGH that helps with financial assistance to avoid eviction. So definitely look to see if this is something that's available, because there's also help with utilities, even if they've kept up with rent. And then the second program is the PA Homeowners Assistance Fund for homeowners at or below 150% AMI. And it's primarily for mortgage, but they can also receive up to $10,000 for delinquent utility bills. This is closed to new applicants currently. But if your clients applied for PA half and they're waiting, please note that the Pennsylvania Housing Finance Agency, PHFA, is in transition. So that's why it's closed to new applicants at this time, and they're working to process the pending applications. Next slide. Okay, so universal service programs. When I'm talking about universal service programs, we're talking about the utility-run universal service and energy conservation programs. So next slide, I want to start with CAP. So this is available to customers of the regulated gas and electric companies and some regulated water companies for their low-income customers to receive these benefits, reduced rates and a lower monthly payment based on their ability to pay. So many programs are subject to annual limits. So oftentimes this is known as like your cap credit. And then so if they it's a common issue for clients with high usage to use more than their allotted cap credits each month, and then as a result they use them all and then they're out. So this can be due to a housing issue, medical equipment that's used causing high usage, or other reasons that are beyond their ability to control. So definitely watch for CAP participants who might use all of their CAP credits before the end of the year, because that next bill might surprise them. There are some exceptions to the maximum CAP credit limits for households if they are using it for medical reasons, or if it's for usage that's beyond their ability to control, like for housing stock or inefficiencies in their housing or their furnace or appliances. Another benefit of this program is that when they enroll in the customer assistance program, and utilities call this different names depending on which utility it is, if they have past debt, it gets frozen. And then with each on-time payment over the course of a certain amount of months, a portion of that debt, so a fraction of that debt, is forgiven over time. So to be eligible for CAP, they have a threshold of 150% of the federal poverty income guidelines or below, and then which would mean that they're payment troubled and they'll be subject to periodic income verification. They can ask for your social security number, your client's social security number, when they enroll in the program, but it's not required. So if your client, for privacy reasons, or if they're undocumented and they are not providing their social security number, that's not a barrier to getting in this program. I mean, they'll need to show their identity and their age in other ways. So ask for a list of what other types of documentation that they can show to provide to meet these ID requirements and to show that they're a PA resident, and get them enrolled in CAP for sure. The next slide, we'll talk about the hardship fund program. The benefit of this is quite simply a cash grant. So up to $500 to help a family or household to resolve a crisis. So typically the eligibility is going to be for those at 200% of the federal poverty income guidelines or below, and it's a little bit higher threshold than CAP. So keep that in mind, that if they can't get CAP or LIHEAP, they may be able to get a hardship fund to help on their account to keep service on. So they are looking for like a good faith payment effort, meaning that they've made some recent payments on their account. It doesn't matter how small. So this is why we always say it's important to try to keep up with their monthly payments, because it can help for their eligibility to get them approved for a hardship fund grant. And so there's also this requirement that there's a temporary hardship in their household, and that's defined pretty liberally. Whatever hardship that they're experiencing will qualify them for this. And then this is the hard one, is that the grant must resolve a problem, or resolve the problem. So what are we talking about when we're talking about problem? We're talking about the crisis here. So if they're facing termination and their past due amount on the account is $1,000 and the max hardship fund grant is $500, that they may need to combine other types of assistance, like for example, LIHEAP, or maybe an out-of-pocket payment, or some other contribution to avoid the crisis. So utilities may accept less. You just have to ask.
Gia, we do have two questions before we move on. I believe they're both from Elaine. Cash grant. The first question is, cash grant means that the money goes directly to the client's ? Would you want to take this one first?
It doesn't. It goes on the account, on the utility account. It'll just be applied to the balance.
And I believe it's still Elaine also asked, if not, what's the difference between a cash grant and other grants? And I think what this means, Gio, if I can take first shot at this question, is differentiating the difference between hardship grants and some of their forms of grant assistance that might be available for utilities, for example, LIHEAP. And I really think that the major difference that's going to be important, at least for our purposes here today, is the source of funding that the grant is coming from. So for example, if the hardship grants and the hardship funds are directly from the specific utilities, the rules are going to vary, therefore, by the utilities. So keeping an eye out what those individuals' rules look like is going to be pretty important. Whereas things like LIHEAP, their cash grants, for example, are going to be administered on the statewide level through DHS. So their rules are going to be obviously more uniform across the state. I hope that answered your question. And I think there was one more question that came in while I was talking. For all of these programs, can you be an equitable owner, such as an heir in a property where the owner is deceased? So I will say that I am not expert nor pretend to be in trust and estate. So there might be a lot of things entailed that kind of overlap with that area that I would have to defer. However, I will say that in order to qualify for LIHEAP, you have to still meet those criteria that we, for assistance in general. So let me talk about assistance. So if you're talking about LIHEAP, you have to meet those criteria in terms of the home heating responsibility, the residency, and all those other criteria. If in that case, you can still get assistance through that. So Michelle, if you're asking for the programs that are utility run that Gio was just talking about, you have to be a customer. So you have to have that customer responsibility. And if there's questions about whether there is a customer responsibility being formed, we encourage you to, one, you can reach out to us, but also reach out to the utility you're working with. And I think there might be a poll that's coming, though. Kelly, please let us know if we are incorrect.
No, thank you very much. This is Kelly. I'm launching the first of the CLE polls. Attorneys will have 2 minutes to respond in order to receive CLE credit, and you must respond to this first one, and then there'll be another one coming up. And please feel free to continue. Thank you.
Thanks, Kelly. So next slide, the LIHEAP program stands for Low Income Usage Reduction Program. The benefits of this would be that they would come in and do an energy audit and then determine what energy conservation measures are appropriate to help reduce the energy usage in the home. So the eligibility for LIHEAP would be those, well, it varies by utility. So either below 200 or 150% FPL. If they rent, if they're a tenant, they will need landlord approval. And then also there's this high usage eligibility. So they have to be using a certain amount of energy in the home to qualify for these measures to be installed. And oftentimes when a client enrolls in CAP, the utilities will refer them right over to LIHEAP, and they might be required to participate. However, if their landlord won't sign off, they're not going to be penalized or taken out of CAP for not participating in LIHEAP, but it might be something that they're asked to participate in. So the next slide discusses CARES. So this is oftentimes forgotten about or little used, and it's important to note because the utility has a wide discretion to resolve customer issues through this customer assistance referral and education services program. But you have to ask, you have to tell them, you know, that your client's having trouble paying their bills, or they're having some sort of short-term problem that's causing the inability to pay. And then the utility can often refer them to social service agencies, give them budget counseling, or this is the one that will help special arrangements. So maybe a longer term arrangements to pay off their bill. So if they're not eligible for these other programs, they might have a higher income, but they're still having trouble, CARES is the way to go. We often use this for clients that call us that indicate that they are a survivor of domestic violence, because they can help address those issues and give them a longer payment arrangement through CARES and all the other protections that they're entitled to. At this point, I'm going to pass it back to Ria to talk about termination and reconnection.
Thanks, Gio. So let's move to the first slide, which is kind of an overview slide of general advice for customers or clients who are facing issues with termination or possibly issue with a reconnection. So first, be proactive. So work with the utilities. If there's something on a bill you don't understand, ask questions, get copies of bills, and definitely, as I mentioned, ask questions around those numbers because they're not always obvious even to people who do this every day in terms of looking at these numbers. So then we encourage customers to pay what they can when they can. This improves payment history that the utilities see on the account, but it also helps if there's an undisputed amount on the table to keeping up with those to make sure that that doesn't become eligible for termination as well. Then, as I mentioned, contact the utility. And this is important not only to get background information about bills, but also provide income information if the person or customer is low income or if they might qualify for some other income eligible program or service. Then apply for those available assistance programs that Gio walked you through, especially CAP programs that can help get down the bill and really deal with arrears that were accrued prior to CAP, and really some of those other programs that can really help resolve not only arrears, but also help with current and continuing bill amounts, such as, for example, LIHEAP. Then determine whether special protections apply as well. We'll be talking about these in a few minutes, but there's some special protections that help with termination, help people stay connected. If the person is, for example, a medically vulnerable consumer customer, if they're a survivor of domestic violence, if there's tenants, there's some special rules and protections that apply as well. We'll be talking about these in a little more detail in the next few slides. And then if the assistance programs and these other available protections haven't helped resolve the issue, look at the option of potentially a payment arrangement. There's some pros and cons about looking at payment arrangements. We'll be discussing these in a few minutes as well. But if assistance programs, which is kind of your first line of defense, if you're working with the utility, does not work, sometimes payment arrangements can help fill some of that gap as well. And then if you're working with the utility, there's still a dispute on the table, there's still an issue that hasn't been resolved, you can file or lodge a dispute or complaint with the utility. You can also lodge a dispute or complaint with the Pennsylvania Utility Commission. We'll walk you through at the end of this presentation what a little bit of information about what informal and formal complaints before the PUC look like as well. And then finally, we don't recommend this by any means as a first line of defense, but if you're working with someone, especially if they have higher balances, we sometimes do refer for bankruptcy consultation. It's not something that we handle ourselves at PULP, but we sometimes give referrals in certain situations. All right, so let's discuss some general termination rules. So terminations can only occur Monday through Thursday. So no Friday terminations, no holiday terminations. So if you're working with someone who has a termination notice, keep those in mind if you're looking for when the actual eligible day of termination will be. Then terminations can occur for a number of reasons. The one most likely you're going to see again and again if you're working with utility customers is termination for non-payment of an undisputed delinquent amount. So there's also a number of other reasons that terminations might be seen that you run into with some kind of frequency, including failure to comply with terms of a payment arrangement. And again, we'll be talking about some of the pros and cons of payment arrangements in the next few slides. Failure to complete security deposits. This can be particularly tricky, especially if you're working with a customer who doesn't meet that security deposit waiver, if they're not CAP eligible, as the case may be. And then failure to permit access to equipment that might be on a property. So some other just general rules about the notices. So these are the termination notices that are required prior, at least with those regulated utilities, prior to termination of service. So first, written notice has to be sent, and this is going to be essentially a window between 10 and 60 days prior to termination. So it has to be sent at least 10 days before the termination, and then the notice is effective for 60 days. So that's essentially that time period you're looking for or looking at when you're dealing with written notices of termination. In addition, there is also personal contact requirement, and this is that 72 hours, so 3 days prior termination. There has to be an attempt, keyword attempt, by the utility to contact the customer. Now, this does not need to be in person. This can be in person, this can be by phone, and it can also be electronically. One rule that we're going to spotlight here about electronic communication, so by email or text, is that the customer must have affirmatively consented to receive that notice electronically. Now, while that is a rule, keep in mind, even when think about all the things you sign when you sign up with the utility, consent maybe have been obtained by the utility from the customer as they're signing up for services. So it might not necessarily be something that the customer even necessarily remembers consenting to, but it might be on the book. So you definitely have to check to make sure that updated address information is there for the customer, updated contact information, updated electronic contact information in terms of emails, making sure that if that notice is sent, that it'll be sent to the correct address, if you will, electronic address. And then finally, there is the last knock rule. This is an attempt, again, an attempt at personal contact at a residence immediately prior to termination. It is not a success at personal contact immediately prior to termination. Now, as we'll talk about in the next few slides, there are additional protections for survivors of domestic violence. If there is that last knock and it's attempted, but it's not in fact completed, there's an additional kind of notice of 48 hours, but we'll talk about that. But the general rule, if you have a customer who's not a survivor of domestic violence, who doesn't have a PFA or another court order, is that the last knock is an attempt. And then I think Naji, before we move on, had a question. How do you dispute an account? So to be accurate, you would dispute the amount on the account. So we apologize about the wording on that. So the key thing is that be specific. So if you're disputing an entire amount, you would say, you're disputing X portion. There can be a portion of the account that's still unpaid that is not in dispute. And that can raise a variety of issues in regards to what can be the valid grounds of termination in terms of notices and things like that. So we always recommend being specific what the dispute is about. So I apologize for any ambiguity about that. And I think there might be one more question that came in while I was talking. And then, do these termination rules apply to all utilities or just regulated utilities? And this is from Julie. Julie, I love to say that it was across the board, but we are talking about those regulated utilities when we're talking about these rules. There's certain provisions and protections that apply, especially in the case of tenants, to unregulated utilities. If you're working with a customer of an unregulated utility, please reach out to us if you have any questions. It can get a little more complicated and hairy, but by and large, if we do not specify, we are talking about those regulated utilities. Move on to the next slide.
And they're
go
not
ahead, Jill.
just, no, if I may add, they're not just home free if they're unregulated. There still are certain protections for tenants, like under the Utility Service Tenants' Rights Act or Discontinuance of Service of Leased Premises Act. So they would have certain notice requirements to let tenants know if, you know, landlords attempting to shut off utilities to the premises. So, but if you do have an issue like that, please do feel free to reach out to us.
Yeah, thanks, Gio. That's a great point. And I think we'll talk about a little more about tenants' rights in the next portion of the presentation as well. But that's a great point that especially in the case of tenants, what we call USTRA has certain applicability for those unregulated utilities. And we'll drop some helpful, hopefully, resources when we get to that section as well. Okay, so as I promised in the last few slides, let's talk a little bit about payment arrangements. So first of all, what is a payment arrangement? So these are agreements whereby a customer first admits liability for billed service, so for a portion of amount, and then is permitted to essentially stretch or amortize the unpaid balance over one or more payments, so essentially over a length of time. So some initial kind of flags for payment arrangements, and this one sounds a little bit obvious, though it happens all the time, is do not admit liability unless you know what you owe. So especially when you're looking at a bill, it might not be obvious on the face of the bill, but what's the actual owed portion, what's the portion to prevent termination, for example. So asking questions around that is very, very important. Sometimes people enter payment arrangements, unfortunately, without them even realizing it. That can be a huge flag as well for this one. So just be careful of entering into payment arrangements before you know what you owe, because you are essentially admitting liability for that amount. And then again, it sounds straightforward, though we run into this all the time. Do not agree to payment arrangements that you cannot afford to pay. So do those numbers, make sure it's actually affordable. Look first at those other options that GEO ran you through in terms of those utility run assistance programs, even in terms of LIHEAP, to see if there are more affordable options and payment arrangements to make sure that the amount is actually affordable for the customer that you are working with. So as you can see from the slide, there are essentially two big buckets of payment arrangements. There's utility issued payment arrangements, and then there's commission issued payment arrangements. So payment arrangements issued through the Pennsylvania Utility Commission. Now, these are going to vary a little bit from one another, and I'll tell you how. So first, utility issued payment arrangements. The general rule here is that utilities have discretion to enter as many payment arrangements as they want for any length of time. So there is a amount of negotiation, amount of discretion utilities have. There is a lot of advocacy that can be done in terms of utility issued payment arrangements. The other flip side of this coin, if you will, is those commission issued payment arrangements. These are much more a creature of statute, a creature of regulation in terms of their rules. So you're looking at these different sections for those of you who want to look them up, but the general rule is that for commission issued payment arrangements, there's those general payment arrangements, which is that first block on that second kind of PUC issued portion, and then there's restoration payment arrangements. So for those general payment arrangements, they're for current customers. So that's going to include customers who within the last 30 days of service or had or service, if you will. So if they had service within the last 30 days, excuse me. And then it's going to, again, be very much set in terms of the provisions that are existing within the consolidated statute. So you're looking at, for a customer with income at or below 150% FPL, essentially a 5-year payback time frame. And there are other time frames set for different income qualifications, if you will. And then the very important rule here is with those PUC issued payment arrangements is that the PUC cannot require utility to enter into a second payment arrangement absent extraordinary circumstances. So getting a second PUC issued payment arrangements or payment arrangement is going to be fairly difficult compared to those utility issued payment arrangements that again are at the utility's discretion. And then, as I mentioned, there is restoration payment arrangements under the commission issued payment arrangements. And this is essentially for applicants for service. So those who've been without service at least 30 days or longer and who are trying to reconnect at a specific address. They may be required to pay a reconnection fee. This is generally, or at least is supposed to be cost-based. And then again, the length of time of the payment arrangement is going to be more tightly controlled. For under 150% FPL, you're looking essentially at 24 months as your period. So some payment arrangement exceptions, I think we've alluded to some of this on previous slides, but there is more flexibility for certain survivors of domestic violence. So for survivors who have PFAs or what we call other court orders that have clear evidence of domestic violence. So you're looking at not the full range of survivors, unfortunately, but certain survivors who have certain orders, PFAs or those other court orders, there is additional flexibility for payment arrangements. So the factors that can be taken into account when looking at some additional flexibility potentially for these survivors include things like the size of the unpaid balance, the ability of the applicant to pay, the payment history of the applicant. This can be particularly important if you're looking at a survivor, especially who cohabitated potentially with an abuser, or the length of time over which the bill was accumulated. Again, what this looks like, especially if the survivor co-resided with their abuser, can vary. So look at those additional factors, talk to utility. You will most likely have to provide a copy of the PFA or other court order to the utility. So there's certain discussions to have with the customer, with the survivor of domestic violence around that as well. So the other kind of exception or caveat we wanted to give on payment arrangements are related to cap arrears. So those are arrears that are accumulated while the customer was in cap. So essentially, if they couldn't keep up with their cap payments. So essentially, if you're looking at those cap arrears, they're unfortunately not eligible for payment arrangements through the PUC. So those commission issued payment arrangements. So a lot of times too, if you're looking at utility issued payment arrangements, they generally will not be cap arrears generally will not be qualified for utility issued payment arrangements. So the tip here in terms of advocacy is that a lot of times if you're looking especially at a termination notice, it's not always clear in terms of the full arrearages, what are cap arrears and what are non-cap arrears. So sometimes the customer only has to pay their cap arrears, so their missed cap payments, to be reinstated in cap. And then the remainder of the payment should be able to be folded in to that pre-cap arrears that should be eligible for arrearage forgiveness. So again, asking what those numbers and how those numbers are separated can be very important in the case you're dealing with someone who was on cap and no longer is on cap and is trying to get back in cap. And again, reinstatement in cap should freeze the non-cap debt and allow forgiveness over time. So hopefully that might be an avenue for some individuals. And then some additional strategies for preventing utility termination. This is a little bit of an overview slide as well, some of which you've already talked about in some detail. So first, look to those assistance programs. Gio's already walked you through a lot of those. I've walked you through LIHEAP, but CAP, hardship funds, LIHEAP, all can be invaluable tools to not only deal with past debt, but also a bill affordability essentially on a forward-going basis, especially CAP. And then look at those additional protections. So if you're working with a customer who is a survivor of domestic violence, who has a PFA or an other court order, there are special payment arrangements potentially that might be accessible. In addition, and I think we'll talk about this a little more in the next few slides, but there's additional special protections available to these qualifying survivors, including that they cannot be charged for debt accrued in someone else's name, even if they lived at the home when the debt was accrued. This includes the abuser. So very important note. There's also that additional notice of termination I alluded to in the last few slides. So again, that's that last knock. If the last knock is attempted, but it's not successful, there's an additional period essentially of 48 hours where the person can't be terminated. So essentially the utility has to go and come back then. And then payment arrangements, we already talked a lot about. So keep in mind there's restoration. There's also PUC issued payment arrangement. There's utility issued payment arrangements. Medical certificates we'll talk about in the next few slides. Medical certificates do not deal or resolve underlying debt, but they can be invaluable tools to prevent termination if you're working with someone with a medical condition or serious illness that requires utility services. We'll again give you some more information about that in a few slides. And then, as Gio mentioned at the top of this presentation, we are, for the next day and a half at least, still in the winter moratorium. So it's that seasonal moratorium for regulated utilities from December 1st to March 31st for households who have income at or below 250% FPL. So again, this is a moratorium on termination. It's not a guarantee of restoration if service is already off. And again, you're looking at those regulated utilities. I will say, depending on which part of the state you're joining us from, there's might be some different rules around the winter moratorium. Out in Pittsburgh, there are certain different lines if you're a water utility customer with one of the regulated waters. So check if there's special rules and additional protections within the utility for winter moratorium protection as well. And then a 4-year rule, this is essentially arrears over 4 years old cannot form the basis of a termination. So if you're looking at really, really old debt, this might be a rule that comes in handy for you. And then we'll be talking about additional tenants' rights and protections around USTRA, as Gio mentioned later in the presentation in a few minutes as well. And I'll be walking you through some of the dispute filing process before the PUC and some of our tips related to that. And as I mentioned, if all of these kind of checklists of things do not result in positive results, and there's a lot of underlying debt especially, we sometimes do refer out to bankruptcy. And I think there is a few questions that have come through. So Elaine, it looks like you're first asking, can the commission direct the utility to reinstate to cap and have the client pay cap delinquency and installment payments going forward? Or must full cap default be paid before the client can be restored to cap? Now, I'll tell you what we've generally seen, and Gio, feel free to interrupt if you've seen something different. But in theory, if there's a complaint filed with the PUC, there can be some action taken. But the most likely way that we've honestly seen it handled is that the cap default generally has to be paid before the client is restored to cap. Gio, have you seen any special circumstances, like in cases of complaints, that there's been more success with that?
No, that's the way I also understood it. The PUC is not going to give a payment arrangement for cap arrears, and they're going to, the client, the best way forward, if they've missed cap payments and all of that debt came back on their account, is to try to have them pay the cap catch-up amount to get them and re-enrolled back in cap.
Okay, thank you, Gio. And Elaine is also asking, can a 4-year plus debt be relied upon to refuse to restore service, or only can't use to terminate? And if only debt accrued over many months, some of which occurred more than 4 years earlier, but others within that time, I guess, does the debtor only have to pay debt which was actually incurred less than 4 years ago, or the entire debt? So I'm happy to hopefully chunk that off successfully. So the 4-year rule is essentially cannot form the basis of termination. It should, in theory, also not be looked at in terms of the time frame for restoration, though I feel like I've seen some variation in this. The one thing is that this is the termination and restoration. It doesn't necessarily mean that the person might not always or might not end up owing that amount, especially if it's something that's been referred to collections. We can't necessarily advise on that, but in terms of the termination and restoration rules, that's generally how it goes. And then, sorry, there's one more portion that might have come from Elaine as well. Will a client be restored to CAP if the client files a BR?
Bankruptcy?
Okay, thank you. It took me a second. Now, I am not a bankruptcy attorney. I do not know the rules of bankruptcy. So I think that would be something I'd have to refer to a bankruptcy attorney to see what specific debt is wiped and not wiped in terms of utilities. So generally, if you're looking at the CAP, missed payments, if that's still on the table, that's something that would potentially stand as and Elaine, if the debt will fully be discharged, I'm assuming if that CAP a debt is also wiped, that should be something that would be wiped for the purpose of looking at CAP eligibility. There might be a holding period. So if the person fell off of CAP within a certain amount of time, so potentially 6 months to a year, utilities might have rules how quickly they can get back on CAP would be the only thing I would say. Gio, do you have any other insight you've seen about that you want to add?
No, I've never seen a case where someone had their debt discharged in bankruptcy and then was attempting to enroll in CAP or, re-enroll in CAP. So, but we can get back to you on that. I think I'd like to talk to our ED and see if there's any clarification we can provide on that bankruptcy question.
And for the ins and outs of bankruptcy, again, we'd have to refer, but if there's any additional clarification we can get on that, we'll get it for you. All right. So some additional notes on connecting and reconnecting to service. Again, this is past that 30 days of when service has been off and you're trying to either connect or reconnect. So security deposits, we've talked about a little bit in the previous slides, but some rules on security deposits. So a customer can be charged up to essentially 1/6 of the estimated annual bill. So that's about 2 months of that annual bill. And again, that's estimated. So that might not actually be what the annual bill ends up being, but that's essentially that amount you're looking for or looking at. Then utilities must provide a customer with also 90 days to pay the full deposit. So this is essentially, if you're looking at it, essentially a 50%, 25%, 25% split. That's something you'd have to do the math on depending on what that estimated annual bill, so that 2 months is. And then third rule we're going to give you is that deposits may be held until timely payment is established. So this is defined, as paying the in full, all on time amount for 12 consecutive months. So that's the general period you're looking at for security deposits. And then, as I alluded to earlier in the presentation, there is a waiver, if you will, for CAP eligible households. So these are households at or below 150% FPL. Now, this is CAP eligible households. It doesn't actually mean that the household has to be enrolled in CAP, which is an important distinction. However, proof of income must be provided. And for those of you who want more information, we have provided the consolidated statute section. There is also an exception or a waiver, if you will, for those survivors of domestic violence with a PFA or other court order. There's a potential waiver available if the customer can establish what we call creditworthiness. This may be a little bit difficult to do, but it sometimes can be established through things like employment, past residences, letters of reference, credit reports. All these things can potentially result or define credit worthiness. And then a third-party guarantor is another way of potentially getting an exception or a waiver to a security deposit, though this can be sometimes particularly hard to get depending on who you're working with. And then some strategies for connecting or reconnecting to services. Some of these, again, are just an overview of what we've kind of already gone over. So again, no security deposits for CAP eligible households. Again, they're not actually required to enroll in CAP, but they have to show some kind of proof of income. And then as we talked about before, there are certain additional protections available for survivors of domestic violence who specifically have PFAs or those other court orders that show clear evidence of domestic violence. So again, just as a reminder, you cannot charge the victim arrears accrued in someone else's name, even if they lived at the residence when their arrears were accrued. There's also some flexible payment arrangements. We've already talked about this based on certain individual facts and circumstances. And then to Elaine's question, that 4-year rule, arrears not only cannot be used as termination grounds, but arrears that are more than 4 years old cannot be required to be paid as a condition of providing service. And then we've talked about this as well. There's those utility issued payment arrangements and commission issued payment arrangements. So the golden rule or general rule here is for those utility issued payment arrangements, the utility has broad discretion to enter into any number of payment arrangements for any length of time. But if they do refuse to enter into payment arrangement, the customer can go and seek a commission issued payment arrangement, which is more a creature of statute and regulation, if you will. And then again, just as a reminder, for those commission issued payment arrangements, there are certain FPL ranges. So I know we talked about the under 150%. If you're working with essentially the higher, slightly higher income group of 150 to 300%, you're looking at essentially 12 months. If you're looking at 150% or below, you're looking at 24 months. Again, these are those restoration payment arrangements. And then, and the rule with the commission issued payment arrangements is that no payment arrangements if essentially there's been a default or 2 or more arrangements of the same balance. So you do have a finite amount of commission issued payment arrangements that are accessible. And I think I am turning it back to Gio. Correct me if I'm wrong, Gio.
Yeah, now we're going to talk about special protections for certain utility customers. Next slide, please. So we've got these groups of utility customers, first tenants, then customers with serious illness or medical conditions, and then lastly, victims of domestic violence. Next slide. So I guess we're starting with domestic violence protection. So if this is your client, at first step would be to advise them to put a copy of their PFA or other court order on file with the utility, so that they have that provided to them with clear evidence of domestic violence, because that will entitle to them to the following protections, which are that the utility can't charge them for debt that's accrued in someone else's name. And this includes the abuser's name, even if they lived with them, cohabitated with them in a residence when the debt was accrued. So they're not going to be terminated for this. And also if they have that debt on the account, they're entitled to flexible payment arrangements based on the individual facts and circumstances of their case, which Ria went through each of those bullet points on a previous slide. Also, they are entitled to additional notice. So when we talked about, what types of notice the utilities need to provide to customers before terminating them, there's a little bit more that they have to do if they have this PFA or other court order on file and they know that the customer is a survivor. So they'll have to attempt personal contact immediately preceding the termination. As we know, there might be reasons why somebody in this situation wouldn't be willing to open the door to a stranger. So they have to try to personally contact them, and if they can't personally contact them immediately before terminating them, they're going to post a notice at the property, and they have 48 hours before they'll come back. Next slide. So for those who have either the customer or someone in the customer's household that has a medical condition, so a serious illness or a medical condition that requires utility service to treat their illness, this is for you. So if you or someone in your household has this, you can get a med cert. So for example, this could mean that someone in your household has asthma, they require air conditioning in the summer in the home, or if they have diabetes, then their medication requires refrigeration, thus electricity. This is a few examples of why you would need a med cert, and it's not up to the utility to decide if your illness or medical condition qualifies. It's up to a medical professional. So we've got the benefit of this. If you call your utility and let them know that you're going to be obtaining a med cert, this will buy you 3 days to talk to your medical professional, and if you do actually obtain the med cert, it can stop termination for up to 30 days. So every 30 days you need to renew it if you pay current charges by the due date. And so you can renew it up to twice, 90 days, even if you're not paying the current charges. So let me reframe that a little bit. Once you get the med cert, it's valid for 30 days, and then you can renew it again twice without paying the current charges. But we advise to try to pay the current charges, because if you don't pay them, then after that 90 days, it's up. And there's not I see a question in the chat. Are there income limits for medical certifications, from Joanna? So no, this is a protection from termination that's available for those who just have a serious illness or someone in the household that need utility service to protect them from getting shut off.
And Gio, there's one more comment from Susan that says many doctors refuse to issue these anymore. And we are unfortunately seeing that on our end as well, especially with some of the larger systems. That's why this holding period is particularly important, to find a provider who's willing to and able to provide that. But unfortunately, we are seeing a lot of that on our end as well. So you are not incorrect.
Yeah, I apologize. I didn't see your question, Susan. Yeah, we recognize that 3 days is not very long to find a doctor, but that as soon as they receive that notice and they know that, or if they're facing termination the next day, definitely call and get that extra time to try to use this as a last resort effort. Next slide. Next, I want to talk about the tenant protection. So the statutes that pertain to continued service for tenants include USTRA and discontinuance of service lease premises, actually known as subchapter B. So first, USTRA, it is applicable to municipal utilities that provide service within their corporate limits, so within their jurisdictional bounds, and that are not subject to PUC jurisdiction. And in the chat, we're going to provide you with like a sample of what an USTRA injunction and pleading would, like a sample of what it would look like to help if you have this issue arise. And you also, if after this you need it, please send a request out. I also intend to send it out with the PowerPoint slides and other resources too. And then secondly, discontinuance of Service Lease Premises Act is applicable to those that are under jurisdiction of the PUC. Next slide.
And Gio, before we move on, Elaine did have one additional question on the medical certificate slides, I believe. She's asking if medical certificates can be used to restore service.
So yeah, if they're already off, call and get the med cert, and this will turn it back on for that 30-day period. Okay, so the rights under USTRA are, or they arise when a utility company terminates someone's service, a tenant's service, due to non-payment by the landlord ratepayer. So if a landlord's name is on the bill and the landlord stops paying, and then that triggers a termination at the address, that's when USTRA applies. It also can apply if a landlord is voluntarily requesting to shut off service at a tenant's home. So these things must be true for USTRA to apply. Landlord is the utilities in the name of the landlord. So for USTRA, it doesn't matter whether the lease says it's the tenant's responsibility. It's just that it's in the name of the landlord. And then for the Discontinuous Lease Services Lease Premises Act, you would know it would have to be that the landlord is responsible for service under the terms of the lease. But neither of them have a requirement to produce a written lease. And then so also when the tenant took possession of the property, utility service needs to have been on or active. And then lastly, the proposed termination of service is due to non-payment or voluntary request, as opposed to, you know, maybe they need to make a repair, or there's an unsafe condition, or if there's meter tampering, then this wouldn't apply. I think I see something in the chat.
Oh, that was just me,
Oh,
Gio.
it's just you. Okay. Next slide. Okay. So we've got tenant's right to notice and continued service. So the utilities need to let the tenant know that if they believe that the unit is occupied, they need to let them know that they're going to be affected by the shut off at least 30 days before. And then tenants also have the right to continued utility service if they pay the last 30 days of or an amount equal to the bill for the last 30 days preceding the notice. And then for subchapter B, they need to just pay an amount equal to the 30-day bill. And then they must pay for bills for future billing months or 30 days or less period in order to receive continued service. And then they need to make that payment within 30 days of the delivery of the notice to tenants. So possible remedies if you have a tenant client, first would be to try to negotiate with the utility provider to continue or restore service. We do have contacts for these PUC regulated utility companies, like most large electric and gas companies, and some water too. Note that the tenant isn't required to put the bill into their name, although it might be prudent to do so depending on the individual facts and circumstances of their case. If they can afford to pay, arrange to have them pay, but if they can't, just at least demand that they post that proper notice and give them their full 30 days before they're subject to termination. You can also make a complaint with the Attorney General's office, and you can help them to file this complaint and follow up with the contact, or file a complaint with the PUC if the utility that's doing this and is PUC regulated. And then also they can start a private cause of action against the utility company. So courts have held that the utility services tenant are, sorry, the USTRA Utility Service Tenants' Rights Act has an implied private cause of action, and they can also consider other claims as well, like for lack of due process or violation of the UTPCPL. Next slide. So additional tenant protections, we've got the right to deduct payments from rent. So if a tenant is making payments on a utility account that was in the landlord's name and the landlord stopped paying, they have the right to deduct these payments from future rent. Also, if the landlord attempts to retaliate or evict them, there's a prohibition against that. They cannot attempt to use this as a way to constructively evict a client or their tenant. So if they're calling the utility and asking for service to be shut off to the home, that's when that applies. And these protections cannot be waived. So they expressly provide, that there cannot be waived in the lease, and their tenants' rights, or any waiver of these tenant rights, are void and unenforceable. I also want to quickly mention foreign load. So if your client believes they're paying for service in a shared or common area, like a lobby or a floor hallway or another residence, it's called foreign load. And these apply to PUC regulated utility companies only, like most large electric and gas companies and some water companies, where they can call and ask for an investigation. The utility will send someone else to check the meter or the breaker. And if they've been paying for service that they shouldn't have been paying for in a common area, the utility company will put the account and any current debt on the account back into the landlord's name until the issue is fixed. If you have somebody with that applies to, please reach out to us so we can help you address foreign load or other tenant issues.
Yeah, Gio, I would just add, related to foreign load, it sometimes does, as you've kind of alluded to, require a lot of investigation and conversation. So if you're dealing with someone who might have a foreign load issue, definitely let us know. It might be something we can help consult on.
Okay. Landlord shutoff or constructive eviction. So landlords who are bad actors and tampering with meters or cutting service lines to their tenants' apartments. This is akin to what you would call an illegal lockout under the landlord-tenant code, and it may be necessary to file an emergency injunction, and it's helpful to get info from the utility company to confirm that they are not the ones who shut off the service, and the tenant might need that as evidence, to file this injunction. Next slide.
And Gio, before we move on, there's a comment from Dawn. Foreign load, their arrearages go back into the landlord's name also, I believe. If you can prove that there's a foreign load issue, that should be correct. But again, this one can get a pretty hairy getting timeline and location right. It normally does take some investigation. So yes, in theory.
Yeah. And they'll only be responsible then for the charges after the issue's fixed. If it is, in fact, the investigation finds that it was foreign loaded. Okay. Am I passing it back to you, Rhea? Or, oh, sorry, I have one more slide. I apologize. Water Services Act, can't forget this. So this requires a water utility, either regulated or unregulated, to shut off water service to a premise if they fail to pay. And so a municipal sewer bill within 30 days of the date upon request of the sewer utility. So in order to shut off water, they need written notice before termination by the water utility, an opportunity to contest charges. So if they do contest these charges, all the good faith dispute has to be judicially determined, and then they cannot hold the lessee responsible for failure to pay a bill of a previous lessee. So if there is already debt on the account when the client moves in, this would protect that current tenant from paying that bill of the previous tenant. And at this point, I will turn it back to Ria for just.
Thanks, Gio. So disputes with utilities. We've been talking about all the rules and programs and tips about utilities and keeping connected and restoring service. But what happens when there is a dispute on the table with a utility? So some steps that we recommend: first, initiate a dispute with a utility. We'll talk about why. Step one is there in a minute. Second, if that fails, there is an option of filing an informal complaint with the PUC. I'll give you some more information in a moment about that as well. And then if that fails, there's an option of filing a formal complaint. And we'll talk about how that is differentiated from informal complaints as well. So first, initiate the dispute with the utility. So I'm going to actually pause here because I think Kelly is trying to launch the second poll. I apologize, Kelly.
That's okay. Thank you so much. Sorry to interrupt. I'm launching the second CLE poll. It will be up for 2 minutes. Attorneys must respond in order to receive CLE credit. And please feel free to continue. Thanks so much.
Thanks, Kelly. So as mentioned, first step always is initiate the dispute with the utility if there is a dispute. So this is good and advised for a number of reasons. First, utilities do have an obligation to address disputes. They also have a certain amount of discretion in terms of resolving disputes. Second, customers do have an obligation to give the utility a chance to resolve a dispute before going to the commission, so before availing themselves of those complaint processes that I mentioned. So some advocacy tips about lodging a dispute with the utility. So as I mentioned, utilities do have broad discretion to resolve disputes. So asking questions about what's going on with a bill, figuring out what's possible in terms of if there's a ask to pay amount, all very important. We recommend using what we call the magic words. If you're disputing, say, I am disputing. If the issue was not resolved, say, no, the issue was not resolved. Be specific what you're disputing. Again, if there is a certain disputed amount, if there's an undisputed amount, be specific about that. Request the utility or account.
I think she thinks in her head it's going to be her April.
And I'm sorry, might have had someone, I just muted them. So apologies if you were trying to unmute. If there are utility bills that you do not have, request those, see what those numbers are, and make sure that you understand where those amounts are coming from and that what portions are in dispute and what portions aren't in dispute. And if there's a termination on the table, if there's a termination issued, or there's a termination notice issued, I should say, request a hold on the account to prevent termination while the matter is being resolved or being looked into. And then again, that differentiation between undisputed and disputed portions of the bills have to continue to pay on those undisputed bills, so it doesn't raise additional concerns in terms of termination as well. And then let's talk about commission complaints. So what happens if you lodge a dispute with the utility, it is not resolved? What do? You can avail yourself of the informal complaint or the formal complaint process. So you can file a complaint with the PUC. For informal complaints, they are gone or they're funneled through the PUC's Bureau of Consumer Services, so BCS. They do not require legal representation. We have provided on this slide the website as well as the phone number for the complaint hotline, essentially, for BCS. And then the informal complaint will temporarily stop pending termination, but will not restore service that is already off. So an important note to keep on that. And then again, back to the undisputed portion of the bill. So if there's undisputed bills, undisputed portions of the bills, you have to keep paying it while the informal complaint is pending. That could raise, again, other grounds of termination if that is not paid. Okay, and then if informal complaints is not successful, there is an option of filing a formal complaint. Now, formal complaints are a little bit different or are different from informal complaints in the sense that First, they require a formal written complaint. Second, they're more formal, hence their name, because they are heard before an ALJ, an administrative law judge. There are tools of discovery, for example, available, and there are option, or there is a opportunity if you go through the full process of getting an ALJ decision, hence on the complaint. And because of this kind of quasi-judicial system, it can take months to resolve as well. So that's something to keep in mind. And then some additional resources here. Well, we just have a few minutes left with all of you. So we've given you the informal complaint number for BCS, and then the formal complaint website for some more information on formal complaints. And then we've given you also the contact information of the Office of Consumer Advocate, which has its own consumer complaint contact information for some additional resources. And then at the top of our presentation, Gio mentioned that we have a number of resources available, both for consumers as well as for providers. So that top block is going to be for those providers. So we've provided an email and phone number for providers for training and technical assistance. So if you have technical assistance questions, if you are interested in more training, you can use that email or phone number. The not so secret, because I keep telling everyone, is that PULP email address gets you to all of us. So that email address is very handy if you need technical assistance, especially. We ask you to keep that top block to providers only in terms of distribution. For customers or consumers, we do have a utility hotline that for certain income qualified individuals may be able to provide some services. We've provided the email and phone number for them as well. Again, that's for those customers or consumers. And we have limited services available for some qualified income individuals. And then some additional resources. We have, excuse me, a number of PULP resources available in terms of advocates manuals for LIHEAP, one-pagers. I believe we are in the process of updating some of these as well. We also have linked to the LIHEAP state plan. So that's the Pennsylvania LIHEAP state plan. And for those of you who want to do some in-depth information and digging about utilities, we have their universal service plans linked here.
And Ria, we have one question in the chat that we missed from earlier from Peyton Gutierrez, who asked, what is the best way to determine whether or not a provider is under the PUC's jurisdiction? So my short answer is that most regulated utilities are the large electric, natural gas, and water companies. But the long answer is that the PUC regulates like the investor-owned electric, natural gas, and water, wastewater utilities, and then also municipal-owned utilities if they're operating outside of their jurisdictional bounds. And then they also regulate PGW, Philadelphia Gas Works, and Pittsburgh Water and Sewer Authority. But they don't regulate like municipally owned utilities that are in their municipal bounds, except for PGW and PWSA, which I just mentioned. They don't regulate Excel service, broadband, cable, or electric co-ops. So that's if you have a question as to whether the utility that your client has service with is regulated or unregulated, we can help you with that too. So please use that PULP contact info and reach out to us for case consult.
Thanks, Gio. And in the meantime, I threw back up our immediate contact information for anyone who needed it. And I think we are at time, which is good because we are also done with our presentation. So the last thing I'll say before I hand it back to Kelly is thank you everyone for joining us today. I hope you learned some helpful information and tools that you can use going into the spring. Please feel free to keep this contact information handy if you need us, especially going out of the winter moratorium. So thank you again for joining us today.
And I would just say a thank you to Gio and Ria for being with us today and sharing all of this important information. Thanks for joining us, everyone, and have a great rest of the day.
Our pleasure. Take care.
Take care.
Thanks, everyone.